And welcome. Thank you all for joining us today. I am Miriam Seifter, a law professor here at the University of Wisconsin. We have a terrific panel in store, so I'll keep my introductory remarks to just a few minutes. Today's event is co-sponsored by the State Democracy Research Initiative at the University of Wisconsin Law School and the Elections Research Center at the University of Wisconsin. The initiative, which I co-direct with Professor Rob Yablon, aims to foster academic research on democracy, government institutions, and public law at the state level across the nation. The Elections Research Center, directed by Professor Barry Burden, has a mission of fostering cutting-edge academic analysis of national and state elections. This panel today sits at the intersection of those interests. We want to thank Allie Bolt and Levi Bankston for their tireless help in putting this event together. So what are we here to talk about today? In Wisconsin and around the country, the decennial process of redistricting is now upon us. As many of you are no doubt aware, the United States conducts a national census every 10 years, which triggers an obligation on the part of states and localities to draw new electoral district maps. The results of the 2020 census were released several months later than usual, which means that the redistricting process this cycle is even more compressed than usual, with mapmakers hard at work establishing the lines for the 2022 elections and beyond. Already, about a third of the states have enacted new congressional and/or state legislative district maps. Many other states are quite far along in their processes and will likely finish their work in the coming weeks. Here in Wisconsin, it has been an eventful past few weeks, with the legislature passing their maps and the governor vetoing them yesterday. Redistricting is garnering a lot of attention today, and for good reason. The public has become increasingly aware that map making has major implications for who governs and for how politics and policymaking are conducted. District lines can determine whether the partisan balance in the legislative body will align with the polity's overall preferences, or whether one party will wield disproportionate power. District lines can affect whether office holders are likely to face real competition or to be insulated from electoral accountability. And district lines can shape whether or not particular communities have the chance to choose their preferred representatives. The public has also become more aware that those in power often treat redistricting as an opportunity to advance their own interests. They gerrymander the lines to advantage one political party over the other and to give incumbents an edge over outsiders. Over the past decade, we have seen growing efforts to push back and implement reforms to establish more neutral processes and outcomes. Yet, we have also seen the United States Supreme Court close the door on partisan gerrymandering challenges in federal court, which has emboldened line drawers in many states to gerrymander more brazenly than ever before. Given all this, we see it as an important moment to take stock of where districting now stands and to consider what may lie ahead nationally and in Wisconsin specifically. We'll try to address a range of topics today, including efforts to rein in abuses through redistricting commissions and other mechanisms, the potential legal claims that can be brought against objectionable maps, the special challenge of assuring fair representation for communities of color, and the role of courts as fallback line drawers when other actors fail to adopt new maps. That's a lot of ground to cover, but we have a fantastic panel to help us out. Before I introduce our panelists, let me just say a couple of words on logistics. After each panelist gives a few opening remarks, we'll take questions. Please submit your questions anytime during the session using the Q&A function in your Zoom window. I will then gather questions from the Q&A and read them to our panelists at the end. So now let me introduce our outstanding panel. Please check out their full and very impressive bios on each of their websites. Their accomplishments could take up the full hour today, so I'll just give an abbreviated version to leave more time for our conversation. First up, Barry Burden is Professor of Political Science here at the University of Wisconsin-Madison, where he is also director of the aforementioned Elections Research Center and holds the Lyons Family Chair in Electoral Politics. His research and teaching are based in American politics with an emphasis on electoral politics and representation. Emily Zhang is a PhD candidate and former voting rights attorney in Stanford's Political Science Department. Her research focuses on the protection of minority voters in the redistricting process and the enfranchisement of new voters. Ruth Greenwood is the director of the Election Law Clinic at Harvard Law School, where she engages in litigation and advocacy while training the next generation of election lawyers. Ruth litigated 2 partisan gerrymandering cases from the trial level to the Supreme Court of the United States, Gill versus Whitford from here in Wisconsin, and Rucho versus Common Cause. Finally, Rob Yablon is co-director of our State Democracy Research Initiative and associate professor of law here at UW Law School, where he teaches and writes principally on political and election law and federal courts. His most recent article, Gerrymandering, forthcoming in the NYU Law Review, identifies how retaining existing skewed maps can undermine democracy. So thank you all, and without further ado, let me hand it over to Barry Burden.
Well, thank you, Miriam, and thanks to everybody who's with us today. Each of the panelists has just a few minutes to say a word about some aspect of the redistricting process. And I want to talk about two themes in particular. One is about the role of commissions that have become so prominent this year and their shortcomings. And second is how the commission process, or some version of it, has played out in Wisconsin, and where things stand in terms of the various criteria that the state legislature has used in its map making versus the advisory commission that the governor established. So as you have undoubtedly seen, one of the themes from this redistricting cycle has been the prominence of commissions of various kinds across the states, but also their failings. There have been some pretty prominent stories, including a big piece in the New York Times just a few days ago about the problems that have emerged in Ohio and Utah and Virginia, Washington State, Michigan to some degree. But at the same time, I would point out there have been some states where the commissions have worked really smoothly and effectively. In Colorado, a commission made up of 4 Democratic, 4 Republican, and 4 independent citizens produced their map without much strife, and it was approved by the Supreme Court. California's commission seems to be working well. Arizona is trucking along. So the story has really been different from one state to another, depending on some factors that I hope we can identify here. I think what was not appreciated when these commissions were created was just how much politicians would try to affect the work of those commissions. Anything from trying to influence them by having their supporters contact the commission and try to lobby them to adopt particular kinds of maps, to meddling with the map making process itself, to ignoring what those commissions do and acting on their own in the state legislature, to subverting the commissions in a variety of ways, maybe defunding them, maybe pursuing them through legal action. So I think all of those efforts have made clear that the design of these commissions and the resources that they're given to do their work matter hugely, much more than I think was appreciated when they were created. Maybe just a word about the variety of the commissions. If you haven't paid much attention, they are quite different from one another, from one state to another. In some states, they are bipartisan. They are designed to have a certain number of Republicans and Democrats. In some cases, those are equal numbers. In other states, one party has an outright majority on the commission. A number of states have what I would call tripartisan commissions. That's like the Colorado model. Some Democrats, some Republicans, some independents. There are also a couple places that have a truly nonpartisan commission without appointees from either of the parties. In some states, the commissioners are legislators or other elected officials or people appointed by those legislators or elected officials, whereas in other states, they are citizens who have applied to serve on the commissions and are selected through either a merit process or a random draw or some combination. And then the commissions vary by how much they are independent from the legislature and how much their voice is merely advisory versus actually controlling the process. In almost every case, the commissions were created by ballot initiative, by voters who supported them. Many of them were adopted in 2018, and so this is the first time that they're being used. Some are older than that. But I think we're seeing now that having ballot initiatives designed by amateurs or advocates can sometimes be successful, certainly in getting them adopted. They pass almost everywhere that they are offered to voters. But they are also sometimes compromises, things they think could pass versus the design they would prefer to have. And sometimes there are aspects of the commission system that just, I think, are not considered very seriously, or maybe aren't salient at the time that the advocacy groups are organizing themselves. So let me just highlight a few of the failures and then try to find some commonalities that we might think about in remedying these problems. In Virginia, a commission that was passed by voters back in 2018 is being used for the first time. It's a 16-member commission. It has 8 Republicans, 8 Democrats. 8 of those are citizens, 8 are selected by legislative leaders. So it's a perfect balance in a bipartisan commission. It has completely failed from the outset. They could not agree on basics, such as even when to meet. It really is based on the Federal Election Commission model of having equal numbers, thinking that those will offset and produce compromise. But instead, it's produced a hyper-partisan divide, with some of the Democratic members marching out of meetings to deny a quorum, and now a stalemate where the districts are going to be drawn by independent experts appointed by courts, and the commission's completely cut out of the process. In Utah, voters passed a commission in 2018. It was undermined by the legislature as part of a deal in 2019 and made only advisory. And so the maps that were just signed into law by the governor in Utah essentially ignored that commission, created a map that was very favorable to the majority party, dividing up the city, the biggest city in the state, Salt Lake, which is really the only place that Democrats had a shot at winning a congressional seat at least. And in Ohio, voters approved commissions at two different times, once in 2015 and once in 2018. They created a 7-member commission. That commission is made up of all partisans, all elected officials or appointed by election officials. That means that it's made up of the two parties, and one party always has a majority because it's an odd number. If that commission can agree on maps, that's a wonderful thing, and they go into place for the next decade. If they cannot, and only one party moves ahead with the maps, then those get enacted for a 4-year period, and they'll have to be looked at again after 2 election cycles. To, I think, everyone's surprise, the commission was dysfunctional, in part because there was a divide among the Republican majority on the commission, and 2 Republican legislators on that commission essentially locked out the other elected Republicans, the Secretary of State and the auditor who are on the commission, denied them access to staff, denied them access to the software that was needed to draw the maps. They were drawing the maps in a secret location that was discovered only when I think the Secretary of State saw them leaving a building and discovered that that's where the work was being done. It looks like those maps are going to be adopted by the governor. Republicans are now on board despite their infighting, but it has totally circumvented the commission process that was put in place. One thing you'll notice about all of these states where the failures have happened is that the maps are moving fast. They are speeding through, sometimes in just days through the legislature, sometimes merely in hours. A map will be introduced and within 24 hours adopted by one or both chambers of the state legislature. That is really contrary to the design of the commissions, which are expecting a slow, deliberative process that is inclusive, that is transparent, that has a lot of public input. Now, it's true, the late arrival of the census data exacerbated this problem. It forced states to work at a faster pace than they would have liked. But when you see the kind of ruthless efficiency that legislatures in particular are acting with, that is a sign of bad intent. Anytime they're hurrying in this way, it's a sign that they would prefer not to have eyes on their activity. So even if some of these commissions were well designed at the outset and had a lot of these potential shortcomings in mind, I think they are now more vulnerable because of the real hardball tactics that are being used in drawing maps. Commissions that have succeeded in the past, like the bipartisan commission in Washington State, has failed for the first time this year. They couldn't produce a map on time. There are just lots of ways that commissions can go wrong. And legislative meddlers know that and would like to drive them off track anytime they can. I don't think that means we should give up on commissions as a model. As I say, they have worked in some states. I think what we now have learned is that they need some things to be successful. They need clear criteria that they can rely on for drawing the maps to defend their work. They need adequate funding to hire staff, to hold meetings, to purchase software for all of the members to have access to. They need good technology. They need to have the availability of the data and the machinery to draw the maps. And there's some really user-friendly versions of that now that some commissions have used. They also need expertise, and this is where I think the Wisconsin system and others may have gone wrong in not having people who could provide advice for compliance with the Voting Rights Act and other kinds of technical aspects. And then they also need a public face, a PR team, an information officer who can explain what they are doing, because all of the opponents in the state legislature who want to undermine their work have these things. They have press releases and expertise and history and all the funding they need. Now, a word about Wisconsin. Wisconsin does not have an independent commission that was adopted by ballot initiative. That's not possible in our state because of the Constitution. This is a purple state, closely divided between the two parties, very close statewide elections in recent years. The governor appointed an advisory commission called the People's Map Commission. It was independent, had an application process where members were selected through former judges, I think. It took tremendous public input, had months of meetings, heard from experts, and really had the technology and some of the expertise it needed. The legislature essentially ignored the work of that commission and passed their own maps, as Miriam mentioned. Those were vetoed just yesterday. The legislature also voted down the People's Map Commission maps a couple of days ago. Both parties now have allies working with them trying to steer this stalemate to the court they prefer. Republicans are hoping this will be decided by the Wisconsin Supreme Court. Democrats are holding out hope that the Supreme Court won't be the final word and they may have the feds involved in federal district court here in Madison. Now, I think some of the division between the maps that the commission produced and the legislature produced is about criteria. The Republican maps adhered to standard legal criteria like compactness and contiguity, trying to maintain municipalities and counties. The Republicans also introduced a new criterion this time around, which is the idea of maintaining the central cores of districts, of really maintaining the status quo as much as possible and keeping districts the same over time. That was not a criterion that they cared about at all 10 years ago when drawing the maps under unified Republican control, but it is a new one. It seems to be a really guiding principle to keep maps that are favorable to the GOP in place for another decade. The People's Map Commission, although it was not well explained to the public, really emphasized partisan fairness in the maps and to some degree compactness of the districts. Because of that, they were criticized immediately and publicly when the first round of maps were produced for failing to meet Voting Rights Act standards, as some people had interpreted them, for breaking up municipalities and for shaking up incumbents. They had to revise those maps in a sort of embarrassing fashion and produce a second round. But we now have those maps and the legislative maps to put side by side. GOP maps out of the legislature do poorly on partisan fairness. The Princeton Gerrymandering Project is maybe the best source for judging how maps perform on a whole bunch of criteria. And according to their evaluation, the GOP map for the Assembly in particular gets a rating of F on their report card. Out of 99 districts, the map would produce something like 40 Democratic districts in a year like 2018 or 2020 when the Democrats generally won at the top of the ticket. Whereas the People's Map Commission gets an A on competitiveness, and in a slightly favorable Democratic year would divide about 50-50 between the two parties. Where the People's Map Commission has been criticized is on things like dividing municipalities, drawing lines that cut up cities, towns, and villages. It looks as though the commission really just didn't give that serious consideration. When it comes to dividing counties, the People's Map Commission actually does better than the legislative maps, but that has gotten very little attention. The focus has been on municipalities, and that seems to be a kind of underappreciation on the part of the commission as to how important that would be, that it would be a vulnerability, and that municipalities are really important in Wisconsin. They're the basis for election administration. I think also the commission underappreciated how much they would be criticized for not producing as many majority-minority districts as exist under the current maps. That has been remedied to some degree in the revised maps, but it really set them back on their heels for a while without a really good PR operation to explain what's happened. And I think the sad consequence of all of this backpedaling and some of the divisions among Democrats themselves about whether they thought the People's Map Commission's maps were acceptable is that those maps are less likely to be influential or be part of the things that courts consider as they render a decision about the maps that will be put into place. So there's some really important lessons, I think, from Wisconsin, even in this advisory system, but also from lots of other states about what we ought to be doing to properly design commissions for the next round. Thanks.
Thank you so much, Barry. Emily, let's turn it over to you.
Yeah, so I think what I'll do is just pick up on the thread of independent redistricting commissions from Barry and just talk a little bit more about sort of institutional design questions in designing these commissions, in particular focusing on, I think, the model that folks are most excited about, sort of citizen commissions that are independently drawing maps in roles that aren't purely advisory, but actually the folks, drawing the actual maps. And then I'll set the stage, I think, for the sort of discussion of legal claims. And I think already what folks are interested in, the kind of Voting Rights Act claims, racial gerrymandering claims, and the like. So I'll start first with the independent redistricting commissions. I mean, I think, for us interested in the future of these commissions, we are really getting a huge lesson in what works and what doesn't. Two big themes emerge for me, at least from Barry's remarks, which is that the lack of actual tiebreakers, so bipartisan or purely bipartisan commissions that are equally split for each party is just not really going to be a viable possibility, given sort of the kind of pitched partisan polarization we see. The second one is, as I think we've known for a while now, these advisory commissions often don't really have any bite and end up really playing a very small role in the process. We seem still every decade to come up with new advisory commissions with some hope that they will do something more than simply be ignored. But I think as each decade, comes and goes, and as each of these advisory commissions get ignored once again, I think we're starting to learn, they really need to have some real power to do something here. Otherwise, they won't get taken seriously. So then I want to focus on sort of the citizen commissions, the kind of models that Barry said were relatively successful or appear to be more successful in this cycle. These are commissions that involve certainly sort of independent commissioners, so those not affiliated with either party, and are comprised of citizens, so not sort of elected officials. In fact, these commissions are built on, a sort of a fantasy of the political everyman, the purity of, the butcher, the baker, and the candlestickle maker, out in the world, who are relatively free of the taint of, partisan bias. In part, I think, as we've become more and more tired of politicians and their tactics, we've had a real desire to find sort of the pure of heart out in the world and try to get those folks involved in redistricting. I think there are some pitfalls to that model that I think we've already seen in the last cycle that are worth bringing up. The first is that the fantasy of kind of political purity of these individuals is easily shattered, and as previewed by Barry, easily manipulated and sort of turned into a storm by various politicians. We knew this happened in the state of Arizona with the single, swing voter on the Arizona Independent Redistricting Commission underwent basically a kind of personal political strip search, a question of whether she had true sympathies for one party versus another, going through not just her own activities, but those of her husband and, her family members as well. So there is a sort of fragility to folks' expectations about purity of independent commissioners that is something that's really worth keeping an eye on. The second one, I think this is related to what Barry was talking about, is the kind of competence issue. We've found these folks who are pure of heart, in part because they're very far removed from the political process, but you are also trading off something when you do that. And that main trade-off is on the issue of some competence and experience when it comes to redistricting issues. When you have the pressing timelines that Barry described, both inherent to the redistricting process and what was made worse in this particular cycle with the late release of the census data, folks who have never done this before, who are not necessarily particularly well informed about the political geography of a particular state, maybe not more than where they personally reside or what they know, there are going to be some, I think, real competency barriers. And that can end up with sort of inefficient work within the commission or over-reliance on experts who are competent and therefore have some, a potentially sort of manipulatory role to play in the process. So those are sort of two, I think, kind of structural things to bear in mind about even the most kind of promising reforms. As useful and as innovative as they are these two issues one wants to keep one's eye on. In terms of setting the stage for the discussion of the kind of law governing redistricting and whether we can count on those laws to prevent some of the expected ills coming out of the next cycle, as Miriam set out in the very beginning, partisan gerrymandering claims are not viable in federal court. They are in several state courts, not in Wisconsin, but in the state of Pennsylvania, North Carolina to a certain extent, in Florida. And those are obviously states where, are very important states where we can expect a lot of action to be occurring. The second type of litigation is also at the state level. Those enforce various state laws, as various state laws can impose requirements to draw politically fair maps, and those claims can be brought in state court to enforce those standards. But the two big ones, and this is setting up mostly discussion for Ruth, is the Voting Rights Act, Section 2, the plaintiffs can sue to create districts that allow minority voters an opportunity to elect their candidates of choice. These districts can be created based on the satisfaction of certain factors known as the Jingles factors. A few things to know about these claims is just the standard for getting these districts created has gotten tougher and tougher over the years. And also kind of the creation of those districts have sort of saturated over time. That is, short of massive changes in underlying demographics, the number of districts or where those districts should occur are largely known to, both litigants and legislatures, or should be known to them. The other big kind of claim, and this is likely the biggest claim that will be litigated in the upcoming cycle, are what are known as racial gerrymandering claims, the claims flowing out of Supreme Court's case, Shaw versus Reno. And that's a claim that allows one to challenge district lines when, quote, race is the predominant factor determining where the lines are drawn, where they are. It's a sort of odd and interesting claim in the sense that there are sort of a lot of statistics that are often brought to bear in these cases, but appearances play an important role in these cases as well. The major or the most kind of gut level test that is applied in these cases is known as the interocular test, which is just if the map hits you in the face with sort of its where the lines are drawn and what its shapes are. So I'll hand it over, I think, to Ruth to talk a little bit about the interplay, especially between the Voting Rights Act claims and the racial gerrymandering claims.
Thank you, Emily. And I'm sorry, I can't help but start by responding a little to what Barry talked about. And the huge grain of salt you should take this with is I gave input to most of the commission and activists before they passed these commissions in 2018. So the first thing that I would say as to whether we considered how are these things going to be gamed, that was, to me, the number one thing that we talked about, but political realities come into play. So for example, in Utah, it was not possible to get anything except it was only possible to make a commission through the legislation, not through constitutional change. So of course we knew that there would be, this pushback and turning it into an advisory commission. I will also say though that I thought it was pretty clever in Ohio, where it was, hey, there's no chance this commission's ever going to agree. I mean, I think everybody knows that. If you pass a 4-year plan, though, there is a requirement that the plan adhere to partisan fairness. And so that is already being litigated by 2 different sets of plaintiffs. Actually, your old group, Emily, the ACLU, is backstopping Ohio. So the hope was to put in a little bit of backstop when the inevitable happened. The other thing I would say about the various commissions is that I don't think we should call it a complete failure if you go to the court. When the alternative is legislatures that are already gerrymandered drawing their own lines, I think places like Washington and Virginia that are going to go to a state Supreme Court, sure, many of them are elected and they have their own problems, but we generally do see plans that are fairer coming out of courts than we do out of state legislatures. So I think before we say that these models have failed, I think we need to see where we actually end up for the actual election in 2022, because I think there's a lot more processes to take place. And I just can't help but answer Jay Heck talking about the Iowa model. This is one of those things where I would sit down with activists in the state and say, okay, this is the Iowa model. How do you think it will get gamed in this state? And my experience in Wisconsin is if you have an advisory commission of demographers and experts, I think that the legislature would completely ignore them. And so I think that the Iowa model works well in Iowa because they have this wonderful history of respecting the demographers and experts and what they come up with. I think it's pretty unlikely that it would work in multiple other states, but I'm interested to hear what others say. Okay, getting back to this question, and I've talked to a lot of people about this in recent days, the difference between a racial gerrymandering and a Section 2 VRA claim. And I saw also Don Leek asked a question about, what about drawing a district with a BVAP, Black voting age population, of under 50% and how that is affected by the Voting Rights Act. So I'm just going to talk first about Section 2 of the Voting Rights Act. The reason I think that it is confusing is because the standard that you have to adhere to if you are drawing maps, if you are the legislature, the court, the commission in charge, is slightly different to the standard if you are a plaintiff bringing a case. So if I am in charge of drawing maps for Wisconsin, which I am not, I could look at the Milwaukee area, which is where the majority of the Black population are, and say, hey, I think I have to look at actual racial polarization in voting analysis and work out how people vote in the Milwaukee area and say, hey, I think in this area, if I draw a district that's 43% Black voting age population, but given the other people in the district, I think it's actually going to work to elect a candidate of choice of the Black community. So that would mean that in the primary, Black voters are able to choose their own candidate over any other group that's also voting in the primary, and then go on to get that person elected. Now, there are some places where you may need a 65% BVAP district in order to ensure that a community of color can get their candidate elected. You would also need to look at coalition voting, right? Do the Black and Latino, or the Black and Asian, or Black and Native, or Black and Asian American communities, do various communities vote together, and how does that affect your analysis? So you really do need a good amount of people like Barry doing racial polarization in voting analysis in advance to give you a sense of the community. And what is going to work to enfranchise members of historically disenfranchised communities. Once you have worked out what those percentages are, then you can draw districts and run reconstituted elections, right? Run recent elections and see whether the candidates that get elected are the candidates that we can identify from election results as the candidates of choice of the particular minority that you're trying to enfranchise. So that's Section 2. So you wouldn't have to draw an over 50% district if you are in charge of drawing the maps. If you are not in charge, if you are what I usually am, which is a lawyer for plaintiffs who are asking for districts, because of a Supreme Court decision, Bartlett v. Strickland, you actually do need to be able to show that you can draw a district that is 50% plus one vote over either sort of the voting age population or really the citizen voting age population. And there are some issues with the census having had errors and undercounts of minorities and various other things. But if you can draw that over 50% district, and you can show that there's racial polarization in voting, that the community of color, tends to vote together to elect candidates, and those candidates usually lose because there's white bloc voting preventing those candidates from getting elected. You have to prove all of that. Then you have a chance to get a new district. How does this interact with racial gerrymandering? Well, in the past, these claims have been separate, right? Section 2 of the Voting Rights Act is, can I get another district for an identifiable community of color? Can I draw a district? Can I bring evidence of that community votes cohesively? Racial gerrymandering started out actually being brought in the 90s by white plaintiffs who said, I feel like race has infected this decision so much, and I don't like the district that I'm in. The sort of nice thing in the 2010s, I think, was that communities of color sort of regained reclaimed the cause of action. And the main cases where racial gerrymandering was used was by Black communities in Alabama, Virginia, and North Carolina to say, don't pack us into districts. So in Alabama, there was evidence that in some places they had said, okay, we're going to draw a 63% Black district. And the Black community was like, well, you're wasting our votes, right? We don't all need to be in this district. If you put some in a next draw, maybe we could have influence in that district as well. And it got to the point where the case out of North Carolina, the Cooper v. Harris case, the state had arbitrarily said we are setting 50% as where we need a district to enfranchise a Black community must be 50% Black by voting age population. And the Supreme Court, to their credit, said, you can't just pick a number, right? You need to look at what's happening on the ground. So as I say, it might be 43% works for one community. It might be 65% works for another, but you need to actually do that functional analysis. Now, how do these work together? It's really interesting. In the latest complaint filed by LDF and the ACLU in Alabama under congressional districts, they have filed both a racial gerrymandering claim and a Section 2 VRA claim. So they say out of the 7 Alabama congressional districts, one of the districts was purely made to put as many Black people as possible into that district. And there is some evidence from the complaint that seems very damning, where, you know, the guy drawing the district said, well, I wanted to make it 51% Black, and then asked why. He said, look, I don't have any evidence. It's just what I want to do. So if you have no evidence, you haven't thought about it. I mean, that to me is like, that case is, I don't know if that works out at a deposition, that's racial gerrymandering. But they also can say, but there's also a second district, right? So you can keep this district less packed and draw a second district that actually is over 50%. And so it may be the case where not only do you change the makeup of one particular district, but you get additional representation through a second district. So I'm really interested to see how that plays out, because you really need the court to understand these are two different things, right? Section 2 is about vote dilution. Racial gerrymandering is about needlessly infecting the process with race. When I say needlessly, sometimes you do need to consider race, for example, to comply with the Voting Rights Act, but only if you do that in a careful, considered way using experts, not just, I think this would be good. So anyway, that's where I think we're at with those two claims.
Thank you so much, Ruth. Rob, over to you.
All right, well, thanks to everyone for joining us on a Friday afternoon. I'm going to focus my comments on the role of the judiciary in redistricting. And along the way, hopefully I'll be able to answer a few of the questions that I've seen that folks are asking about the situation in Wisconsin. So courts basically wear two distinct hats when it comes to redistricting. First, as I think the comments from Emily and Ruth allude to, one role that courts play is they review maps that lawmakers or other primary map makers adopt to ensure that they are compliant with the law, whether that's federal law, such as the Voting Rights Act or the federal equal population requirement, or whether it's state legal requirements, such as many of the geographic criteria that are in state law. But the second role that courts play, and this is what I want to really focus my attention on, is courts are sometimes called upon to be map makers themselves when lawmakers or other primary districting authorities fail to enact maps themselves. Courts are there to step into the void. Now, this is something that happens with regularity. Often it's because political control of state government is divided and the parties can't reach a compromise, or as Barry suggested earlier, sometimes redistricting commissions can get stuck themselves or miss legally imposed deadlines. During the last redistricting cycle after 2010, courts drew congressional or state legislative maps, or both, in Colorado, Connecticut, Kansas, Minnesota, Mississippi, Nevada, New Mexico, and New York. And this time around, I think we're likely to see judicial map making in a similar number of states. We're certainly headed in that direction in Wisconsin. The same goes for Minnesota, probably with respect to congressional maps in Pennsylvania as well. As Barry mentioned, the deadlock in Virginia's new redistricting commission means that it's now going to fall to the state Supreme Court to adopt maps there, and similarly in Washington state. So when the task does fall to courts, sometimes it's state courts who do this work, sometimes it's federal courts. Under US Supreme Court precedent, state courts generally have first dibs, but the parties may end up choosing by consent to litigate in federal court, or they may pursue claims that are removable to the federal courts, or maybe the state courts choose simply to bow out. And it's a combination of those reasons that explain why in recent decades in Wisconsin, it's federal courts that have done the map making. Now, there is no uniform national process that state or federal courts follow, nor a fully uniform set of criteria that they apply when they step in to draw maps. There are some states that have a special set of procedures that they've adopted for redistricting cases, such as providing that the cases go directly to the state Supreme Court. As Barry suggested, part of the process in Virginia is that the court appoints outside experts to come in and jointly work on drawing the map. But there are many other states, including Wisconsin, that have no specialized procedures on the books. In federal courts, the cases go to a 3-judge panel consisting of federal district court and appellate judges, and the rulings of those courts are directly reviewable in the US Supreme Court. Now, you may wonder, practically speaking, how is it that courts do this work, since they themselves are not political cartographers? Are they really hunched over maps, pencils, and erasers in hand? And the answer is generally not. Unless state law provides more specific guidance, courts usually have two options. They can bring in their own outside experts to assist them in generating maps, or they can have the parties submit maps and then they can choose among those submitted maps. Now, one way or another, all of the courts need to ensure that the maps they approve do comply with the law, and that includes federal requirements such as the Equal Population Requirement and the Voting Rights Act, as well as state law requirements. Beyond that, courts typically do have some discretion, although they have to be attentive to their institutional role as judges, who are duty-bound to act in a neutral and even-handed manner. And for the most part, courts have taken that neutrality obligation seriously, and that includes in the 1980s, the 1990s, and the 2000s, when federal courts drew Wisconsin's maps. So let me offer just a few more words about the situation in Wisconsin this time around. In anticipation of a political deadlock, litigants filed suit several months back in both state court and federal court. The state Supreme Court agreed to take the case as an original action, and so there are going to be no lower state court proceedings in Wisconsin. These cases feature an array of parties. They include institutions like the legislature and the elections commission, individual officials like the governor, and individual citizens and nonprofit advocacy groups. The federal litigation in Wisconsin is now basically in a holding pattern as the court waits to see whether the state court, which does have first dibs, will indeed press ahead and adopt a map. Earlier this week, the state Supreme Court issued an order outlining how it intends to move forward. The court said that the week after next, on or about November 30th, it plans to issue an opinion that's going to answer three important questions that it posed to the parties and had them brief. Those questions address what factors the court should consider as it creates maps, whether the court should endorse a so-called least change approach, which is favored by a couple of the litigants, and whether the court may validly consider the partisan makeup of districts. Once the court issues that order, the parties are going to have a few days to let the court know whether they want to have any formal discovery in the litigation. And the court invited the parties, once they see this order on November 30th, to file proposed maps on or before December 15th. And they can support those maps with briefs and expert reports. The court then said that it plans to conduct a hearing and/or an oral argument beginning on January 18th, 2022, and potentially continuing for several days. So what sort of map might the Wisconsin Supreme Court ultimately adopt? That's the big question. They seem to be signaling a desire right now to adopt a party-submitted map rather than a map that they draw themselves. They have not established any mechanism yet to bring in outside experts to help them do that technical work. Now, the legislature and its allies are seeking this least change approach, one that takes the existing map as a template and then makes the bare minimum adjustments needed to restore population equality. Of course, in Wisconsin, the existing map was aggressively gerrymandered. So in effect, they're asking the court to carry that skewed map forward. Now, if the court takes its neutrality obligation seriously, this is an argument that the court really should reject. I've examined judicial practice across the country on this, and most of the time, courts do not use a least change approach, and there's nothing in Wisconsin law specifically that suggests that map makers are obliged to preserve old districts. In the relatively few instances when courts have used a least change approach, it's only after they've assured themselves that the updated maps would not perpetuate a partisan skew. So in Wisconsin, the federal court that drew the state legislative map after the 2000 census did choose to use the existing map as a template after rejecting the litigant submitted proposals as unredeemable, partly because it said that their partisan origins were evident. And the court stressed that it had an obligation to avoid the creation of a partisan advantage. So it began its work by taking the court-drawn map of the previous decade and building on it. And that previous decade, what the federal court had said about fairness is that the court's obligation is that it should not select a plan that, quote, seeks partisan advantage, a plan where one party can do better than it would do under a map drawn up by persons having no political agenda. So if the court, the Wisconsin Supreme Court really takes those statements seriously, it should not be preserving the status quo of the existing map. And if it instead chooses to embrace that preferred approach of the legislature and carry forward those old maps, that's likely to tell us more about the nature of the state Supreme Court than it is about the nature of Wisconsin law. I'll leave things there for now.
Great. Thank you, Rob, and thank you so much to all of our panelists. So we have about 15 minutes for Q&A, and we have a bunch of questions for those in the audience. Please continue to submit those. I'll start with one that combines some of the audience questions with one of my own. So there's been a lot of discussion on our panel about these independent commissions. Both Barry and Emily gave us a number of factors that are relevant to sort of determining whether the commission is likely to be successful. Ruth talked about some of the political practicalities and making sure that the commission can actually come into existence. And some of the audience members have asked, sort of what would better look like? What are the models? What are the top models that we should be trying to emulate? And then what are the alternatives to those if they won't work? So I guess the way I want to formulate this question is, can the independent commission process be successful? Can it actually work to achieve the goals of the people who are trying to create these commissions? If so, what does that ideal commission look like? And then if not, and here's where my question comes in, if not, should we be thinking beyond districting and districts? And should we be instead putting all of this effort into some other type of advocacy for a electoral system that doesn't depend on single member districts? So whoever would like to answer that one first, please go ahead.
Maybe I'll just say a quick word about the Iowa model, since that came up earlier in Jay Heck's question. I think I'm more optimistic about its value outside of Iowa than Ruth is. Iowa is kind of a unicorn. It's sort of an easy place to draw districts because everything is square. All the counties are square. There aren't huge urban areas. There's not a lot of racial and ethnic diversity. So as someone said, you put Iowa in, you get Iowa out. Maybe almost any system would work pretty well there. But it has been so durable. It's been 50 years under Republican control, Democratic control, essentially no litigation, very little controversy, little expense, little secrecy. I think an Iowa model plus some tweaks could work in Wisconsin and other states. I think the tweaks I would think about are not, so if you don't know the Iowa model, a nonpartisan agency that already exists in state government, something like the Legislative Reference Bureau in Wisconsin draws the maps. They have the expertise and the independence. They're bureaucrats who are there before the districting cycle and they're there after the districting cycle. The maps are sent to the state legislature, which can vote them up or down. They can't be amended. If they vote them down, there's another round. They can be voted down, there's another round. If it goes through 3 rounds, the state Supreme Court would make the ultimate decision. I would probably remove that final step of the state Supreme Court making the final decision, because that's where we are in Wisconsin now, and with elected judges that now more clearly have a partisan leaning. I think it would be better to keep it out of that venue. The fact that it's unamendable and legislators would not know if they reject one round whether they're going to get something they like more or less than the next round, I think is an incentive to kind of take the first thing that seems acceptable. And it's really independent. It's not partisans, it's not bipartisan, it's not tripartisan, it's nonpartisan. And so you don't have people coming forward to want to serve on it to implement their wishes. So that's a model I think that is kind of unique and no one else has been able to replicate, but I think still ought to be our standard.
Anyone else want to weigh in?
Yeah, I guess I would just say in places where it's hard to find a non-partisan. I remember, Colleen Mathis was the head of the Arizona Independent Redistricting Commission. She had been a young Republican and she got accused of being a Democratic shill. And she sort of said, look, it's just really hard to find people that will apply to be on a commission that are interested in politics, but completely non-partisan. And so I do appreciate what you say, Barry, about like people who do this for their life, like they're demographers, they probably genuinely are nonpartisan. But if you're trying to populate a commission, I think the way they do it in California and Michigan, where they just accept, like, we want some Ds, we want some Rs, and then some people who don't identify as D or R, but they probably maybe identify as something else. It seems like a confusing process where there's lots of legislative strikes and pulling people out of ballots and so on. But I think going through that process, you end up and I hesitate to say this today in Wisconsin, but with something like a jury system. But, I think that there have been some successes in the last decades from Arizona and California, and I think that Michigan may end up being okay this time. So I would think that it matters which people you have. It matters what powers you give them. And so, yeah, I think obviously giving them power to do it without legislative input is important. And then the process matters. You have to make it transparent, put it online, get people to give input, make sure there are hearings, not just on, the thing they loved to do when I lived in Illinois was we'll have 100 public hearings, then we're going to draw the maps and hear from no one and then pass them, right? So it has to be like you actually map in public, you actually have input and so on. So I do think it's possible. I like what you say, Barry, about setting up the sort of game theory incentives, right? Like, hey, don't come back to us because you might get something worse. Yeah, it would be nice. And then Miriam, just to answer the other question that you asked about stepping away from a district system. So I presume you mean something more like proportional representation, or even just sort of larger multi-member districts where you elect 4 or 5 people from a district, which can, the main advantage for me in that is that it can really enfranchise minority communities, not just racial and ethnic minorities, but political minorities. So I've been in places where the Tea Party and the Black community together really want to get a different system because they are the 2 minority groups that are being left out. I think it's a great system. To me, it makes sense. You could do it mixed. You could have, like, in Australia, the House has districts, and then the Senate is pure proportional representation, and that gives you some advantages of both. My impression in America is that territorial districting is so entrenched and something that people like, right? They like the idea that somebody who lives near me and has kids in my school district, is going off to represent them is important. And you worry if you do a PR system, it's like, oh, great, we all elected a whole bunch of people from Madison, right? That are not necessarily very responsive to the rest of the state. So it's a lot to consider.
Thank you. Let me turn to another question, and I'll combine several again. There were a number of questions submitted about the process in Wisconsin, what's likely to happen before the state Supreme Court, and then what alternatives there might be once the state Supreme Court approves a map, if any. So one of these questions asks about who can submit a proposed map. Could you be an intervener or an amicus who proposes a map? Could a party introduce multiple different maps for the court to choose from? And then another question is, once the court adopts a map, and the question supposes that it adopts a party map, is there anywhere for someone who's dissatisfied with that result to turn? Would it be federal court with some claim other than the ones foreclosed by Rucho? And if so, what would likely happen there? So I may pitch that question to Rob first, but others are welcome to weigh in as well.
So I'll try to take at least some of that on. In terms of the process that the Wisconsin Supreme Court is following, I mean, really all we have to go on is the order that they issued earlier this week. So in terms of who can submit maps, for example, one way to read the order, maybe the most natural reading, is that they only want maps submitted by the parties and interveners. There is an opportunity that they provide for amici to come in and speak out in favor of a submitted map, but there's no clear mechanism for an amicus to submit a map. Now, if an amicus tried to do that, I don't know if the court would reject it or not, but they haven't specifically invited it. And as I read their order, they seem to be asking for 1 map per party. So I'm not sure that parties will be welcome if they try to submit multiple maps. I mean, in terms of the question, well, what happens if the state Supreme Court ends up adopting a quite partisan map, if they basically carry forward the existing map or ratify the map that the governor just vetoed? There will be few legal options at that stage. To the extent that there is a federal law defect in what the state Supreme Court does, that can be challenged in federal court. But because partisan gerrymandering claims are not cognizable in federal court, that is unlikely to be the pathway. So instead, it would have to be that they adopted maps that, for whatever reason, didn't comply sufficiently with population equality, or they ran afoul in some way of the Voting Rights Act or racial gerrymandering. But it would be a difficult path, I think, to challenge that sort of map in another. In terms of state law, the Wisconsin Supreme Court really is the end of the road.
Thanks, Rob. Just a follow-up question on that about the United States Supreme Court and its possible role here. So we know from Rucho versus Common Cause that partisan gerrymandering claims are not justiciable in the federal courts, and so the United States Supreme Court is unlikely to be involved in that way. But what else might we see the United States Supreme Court doing in this cycle, if anything, in these redistricting battles?
Actually, before someone else answers that, I just want to make sure, I think when I said that where state claims for partisan gerrymandering are available, I think I may have said the wrong states. I think I meant to say Pennsylvania, and I said something else, so I just wanted to make sure to correct the record on that, yeah.
But while you're there, why don't you talk about what the Supreme Court's going to take this time?
Well, I mean, I think that it's going to be the question that I think Ruth talked about, continuing to police how much race and how much not, sort of the line between the VRA and racial gerrymandering claims. And how much the legislature has to have known, what kind of functional analysis will they have had to run, and the like.
Yeah, the only thing I would add, Emily, is before we got to here, I feel like a lot of groups were worried about Evenwell coming up again. So that was a case that the challengers tried to ask that total population be equalized by using citizens of voting age. Having previously been a non-citizen that were voting age, I was very much against this, although now I am one. But and then there was also talk in Missouri of using citizen population, but excluding non-citizens, so including kids who can't vote, but excluding non-citizens who can't vote. And we haven't sort of seen that play out yet, but I don't know. I mean, whether the others here think that, I don't think someone's going to bring a claim again, like Evenwell, to say you have to use CVAP, but I wonder if a state or a local jurisdiction will use something other than total population as their apportionment base.
It wouldn't surprise me if at least some local jurisdiction tries to equalize a citizen or citizen voting age population, and someone challenges that and says, under the one person, one vote doctrine, you have to use total population, and that could work its way up to the Supreme Court. Something else that could return to the Supreme Court, I mean, we have had this whole discussion under the assumption that the commission model is a legal model, that it is allowable for districting to be taken away from the legislature. And the Supreme Court, in a case from Arizona, previously said that the answer to that question is yes. They approved of the Arizona Independent Redistricting Commission rejecting a challenge from the legislature that said that under the US Constitution, the legislature, at least for federal elections, has the prerogative to draw district lines, and that power can't be removed from them. That was a 5-4 decision. It was written by Justice Ginsburg. And Justice Kennedy joined that majority. So 2 of the justices in the majority there are no longer there. And it wouldn't shock me if a party takes a crack at seeing if the Supreme Court is interested in overruling that case, which would make it more difficult to design commissions to circumvent legislatures.
Yeah, and I think if either of those cases went up to the Supreme Court, my prediction would be the commission model is dead and you're allowed to use citizens as your portion.
Yeah, I agree. The one thing I'll say about the commission model is, again, when I was talking with all of these groups about trying to do their commissions, the sort of saving grace is that they're all slightly different to each other. So if they strike down Arizona or California, it doesn't necessarily strike down, Michigan or Colorado or Ohio. I mean, it may effectively, but it will really only strike them down with respect to congressional districts. The state legislative districts, I think, I'm sure there's a theory out there, but for now, it seems like they're on firm ground. I'll also note, Rob, that the author of the dissent in that case was Chief Justice Roberts.
Okay, we have time for maybe one more quick question with 2 minutes remaining. And we've had a couple of questions that get at the process of map drawing itself. Seems that the process of drawing the maps has become more and more technical. This is not a bunch of people just sort of sitting down with crayons, right? There's software involved. There are a lot of experts involved. So I think maybe a way to phrase this question is, what could you tell a layperson about the way that maps actually get drawn?
Well, I'll just say there's a cool thing going on this cycle that wasn't the case in the last cycle, or certainly before that. Something Ruth has been intimately involved with is there are now public tools that will let anybody without technical knowledge evaluate maps basically the day the map is released by an advocacy group, by a legislature, by a commission, or whatever. The Plan Score website that Ruth's involved with is a wonderful source of that. There's the Princeton site I mentioned and others. And so a lot of the tools that were really expensive proprietary things held by the inside consultants are now available to everyone, including courts. And so we can all have a look at the ugliness happening simultaneously. I suppose that's the downside of it all. But there are a number of actually free tools like Districtor, the Dave's Redistricting app, and some others like District Builder that are relatively inexpensive and very accessible to the layperson.
Great, thank you so much. Thank you to everyone for coming today. Thank you to our panelists. This session has been recorded and will be available on both the Elections Research Center website and the State Democracy Research Initiative website. So please feel free to come back and revisit. Thank you all again. Hope you have a wonderful weekend. Thanks for joining us.